back, everybody. I'm Glenn.
I'm Michael.
This is Legally Speaking, and we are coming to you today from, I'm in Lincoln. Where are you at?
Mason City, Mason County.
So we're going to talk today about mistakes that executors we've seen make in the administration of estates. So executors are administrators, and what's the difference in those two things?
So executor is nominated under a will, and if that will gets probated, then the executor is authorized to act on behalf of the estate. An administrator is typically appointed when there's no qualified executor left to act under a will, or if somebody doesn't have a will at all. Either way, an executor and an administrator, administrator have essentially the same fiduciary duties to wrap up the estate, manage the estate, and then wrap it up.
So when you say fiduciary, that means that they have an obligation to work on behalf of everybody that's involved in the estate, whether that be beneficiaries, heirs, creditors. They're not just doing it for themselves, right?
That's correct. They have an obligation to basically protect the best interests of all those individuals involved, and then most importantly, defend and honor a will if that's the case. And if it's not matter where there's a will, then the state of Illinois chooses how that executor is supposed to administer that estate at that point.
Well, that was one of my mistakes with self-dealing, so we already checked that one off the list. I got a few others. What else? You haven't seen the list that I wrote out, so you guess a couple and see if they're on the list.
Well, my number one, maybe selfishly or a little plug here for Woods and Bates, is an executor not hiring a probate attorney. I mean, trying to do it themselves is just such a complicated process. I think we feel confident in our skills, able to walk somebody through that type of process. That's kind of our bread and butter. That's what we're here for. So I think number one thing in my mind, and a mistake that an executor or an administrator makes, is not seeking out an experienced probate attorney.
I think that's pretty close to I wrote taking advice from non-attorneys. So, like the WebMD fallacy. Every time you look up what you have, what your symptoms are on WebMD, you're inevitably going to die. And I think that's kind of the same thing. I talk to people all the time that say, my brother's cousin's uncle is a lawyer and told me this, and they live out in New Mexico or something, which may not be the case here. But that was one of the things that I wrote on my list. I also wrote not listening to the attorney once you've hired them. So if your attorney's telling you something and giving you guidance, not doing what they're telling you, happens. Believe it or not. I know you've experienced that.
A few times, yeah.
One of the biggies that I wrote on my list was, okay, we've opened the estate. I've been contacted by one of the beneficiaries. They want their inheritance and they want it right now. Think that's a good idea?
No, because you have creditors or potential creditors out there. One of the things when we open the estate is we expedite the claim period. Well, if you distribute out all the money before that claim period runs, and on the very last day, a creditor comes in and files a claim for 10 times the value of the estate, well, most likely all the money needs to go to that creditor, and you've already distributed out to Billy and Jane, and they've already spent it. So now you're on the hook. You're bonded to the state of Illinois. That goes back to your fiduciary duty. You most likely will be paying that creditor's claim.
Yeah, and that's not a situation you want to get into, because even if you have, some sort of refunding bond where the people agree to pay it back if need be, if that money's not there, you're in a bad spot. And in all likelihood, if they're struggling and they need that inheritance, and they need that money, the money's not going to be there. So that's one of the things that I see often, and I think it pays to just be patient and not do that unless there's really no option, and that's usually not the case. One of the other things, I wrote two things down here that kind of fall into the same area, I think, is ignoring beneficiaries or claimants and and or arguing, with them. I think that just causes more heartache than is necessary. I think there's a lot of trepidation, I guess, if people aren't getting information. So there's a lot of information that we send out as the attorneys on behalf of the executor or the administrator. And, a lot of that I think is legal in nature. It's got case headings and it's got all this formality to it. And I think some of that's intimidating when they get that. Whereas, maybe a short email from the executor that says, hey, we've opened the estate, we've got to wait 6 months before we're going to distribute everything, but I'm going to give you some updates here and there. I think that kind of sets people's minds at ease a little bit more than just the notices that we're required to send by law.
Right. Give them a realistic time frame and explain to them, look, this isn't going to be something that gets done tomorrow, but in likelihood, if everything goes smoothly, maybe 7 months from today's date, we would have everything wrapped up. And keeping the beneficiaries informed. So then what happens whenever there is a disgruntled beneficiary? The other common mistake that we see is that executor or administrator doesn't keep adequate records. I mean, commingling of funds, obviously that's a no-go. With this adequate record keeping goes, you want to open up an estate checking account. That's essentially your operating account for this new entity. And, I've seen it before where an executor gets appointed and there's a check written to the estate, but they don't open up an estate checking account. Instead, it's deposited into an individual account, which right then and there, you've commingled your funds. Your record keeping is going to be impossible to differentiate between your individual expenses versus the the estate's expenses. So setting up that operating estate checking account and then keeping adequate records, that's going to protect you in the end whenever one of those beneficiaries disagrees with what you've done, and then you have to justify that in front of a judge or a jury of your peers.
Yeah, I think that goes along with, I wrote down not being diligent, and I was thinking along the lines of, okay, attorney's office has asked for certain documents, and taking 2 to 3 weeks to get those to them. I mean, you're just extending the length of the period of administration at that point. But I think that record keeping and diligence as far as doing the job is important too, so that, you're not missing things, you're not blowing deadlines, you're not, if you're an executor and you get a claim in the mail, that's a legitimate claim, whether they've sent it to the attorney or to the court. So you need to do something with that. You need to not wait 3 weeks to take it into the attorney's office, because there's certain periods of time where you have to object to that if it's not a valid claim. And just being diligent, like you said, I think goes a long way. And, I think along those same lines, diligence also speaks to somebody accepting that position when they may not be qualified to do that. I mean, if you know that you are not a good record keeper, that you are not a diligent person, that you are, don't want to do it anyway, don't accept it. I mean, nothing says that you have to do the job, but if you do accept it, you're taking on all those responsibilities, and you're ultimately the one that's going to be on the hook if you don't do it correctly.
Yep, and doing it correctly, that was another one, short top 10 mistake. I don't know what number we're on now, but do what the will says.
Kind of commingled our numbers here a little bit. So maybe
bad example here.
Advice.
Do what the will says. If there is a will, if there's personal property that needs to go to specific people, do your best to get that to them promptly. The caveat is, if there are no other assets and the personal property does have to be sold to pay a creditor, maybe we'd be a little bit more hesitant about giving out the personal property. But if it's something that's like family photos that really has no monetary value, get that stuff to the people as soon as you can, because the longer you hold it, the easier it is, or the more likely it is that you'll misplace it, and then you have, again, a disgruntled beneficiary at the end.
And I'm sure you've gotten this before. Well, the will says that, but mom or dad or aunt or uncle or whatever told me this. This is where they wanted that to go, or who they wanted to have that particular piece of jewelry or whatever. What do you think about that?
Do what the will says. And if those people want to do some exchange of personal property after you've distributed it, that's on them. They can make gifts or exchanges between themselves. But you, as the fiduciary, need to do what the will says, even if one or two, or in your own mind, the decedent wanted something different.
And the last thing that I wrote down was kind of goes along with diligence, I think, is executors that miss assets. So we've closed the estate, several months have gone by, and somebody comes in and says, hey, I found this account that dad had at such and such a bank, and it's got $10,000 in it. You know, what can I do with that? Well, that's a costly mistake, because at that point you have to reopen the case. You have to get your executor administrator reappointed. I mean, they don't have any authority anymore at that point. So you have to kind of start over, depending upon the nature of the estate. You know, that could take some time and definitely some expense. So being diligent about making sure you know everything that's there that needs to be dealt with is really important, I think.
Yep. And the last one I had was making sure that that fiduciary is filing the appropriate tax returns. And I think that comes right to your last point of, you know, if there is a final individual return that needs to be filed, and there's going to be a final refund, you know, you can't close that estate and then you get a check from the IRS 2 months later that says payable to so and so, and you've already closed the estate. Now you've got that asset that you have to again reopen the estate. So you know, making sure you go over the decedent's assets and make sure you know what they have, and at the same time, that's going to help you realize, do they need to file a final individual tax return? Do they need to file a fiduciary return? Is there any estate tax problem? And obviously, if it gets to that point or that complicated, there's going to be a lot of professionals involved, and we'll make sure that gets taken care of. But I mean, in summary, it's kind of take the hand of the probate attorney and follow their advice. And if you have questions along the way, make sure you get those questions answered, and be on top of things and keep everybody involved informed. I think that's a good summary of it.
Yeah, I think that a lot of those things may not be things that a nominated executor would necessarily know inherently, but a good probate attorney is going to know those things and keep them advised, as long as they're paying attention and do what they're advised to do. So I agree with that. And I think, I don't know if we checked them off one at a time, but I think we got through all the ones I wrote down.
Yeah, I think we got through all of mine. They're kind of all combined.
Yeah, there are a lot of overlap there. I don't know. The Cubs are terrible, but the Bears got to win, I guess.
Yeah, Bears won and Packers lost.
Not a bad week.
No, that's a positive NFL weekend for me.
All right. Well, thanks for joining us this week, and we will see you next time.
Thank you.
As an afterthought, our newly self-appointed marketing director, my son, indicated that we are supposed to tell people to smash that like button and subscribe to our YouTube channel. So if you could do that, that would be great. Thanks.